Oh, hello. Hello. Hello, hello. Hit the like button if you're there and say hello in the chat. Hi there, everybody. Please join me for my analysis of Elizabeth Holmes's motion for an acquittal. Please join me, and please do leave a question or a comment in the chat box. So, shall I get started? Let's see. So I'm going to cover in this live stream, I'm going to give you an update on the Sunny Balwani trial. We have some interesting news for today. So I'll talk to you about that for the ongoing schedule, the trial schedule for the Balwani case, who is the co-defendant of Elizabeth Holmes. Then I'm going to talk to you about generally what a motion for an acquittal is. We'll talk about that. What's the likely outcome? What are the reasons that Elizabeth Holmes is asking for the judge to grant her an acquittal, which is to throw out her convictions, to overturn a jury's verdict. So I'll talk about that. In one interesting case that this does happen, it does happen where a judge has in the past overruled a jury's verdict. So I'll go over that too. And again, I'll do the highlights on the Sunny Balwani trial, the update, what's going on, and tell you a few things. And then we'll look at what's the likely outcome of her acquittal motion being granted. So hit that like button and do subscribe if you want to participate in the chat box. And let me know you're there. So hit that like button. Oh, hello. Hi, Tony. Thank you for joining me. Give me some of your questions, Tony. And also, by the way, I do have some of the questions that I have already gotten on the video I did. And by the way, after the live stream, because I want you to stay with me during this live stream, but after the live stream, you can go ahead and look at the video I just posted, the last video I did, which is where I walk you through the motion, Elizabeth Holmes' acquittal motion. So that kind of gives you an idea of her grounds. But I'm going to give you some of the highlights of the grounds that I saw that she has, and whether or not whether or not she's going to have a positive outcome on this, whether the judge will grant an acquittal or not. We're going to find that out. So, all right, let me give you the update on. Hello, Arturo. Hi there. Okay, and by the way, I did put a PayPal link if you want to donate to me making these videos as a super chat, because I have a small channel here. We're growing, but it's a small channel. So I have to do a PayPal link. Anyway, so if you want to donate, thank you very much. Anyway, do ask questions as I go. If you have any, or if you have any comments, please do put it in the chat box. And if you want to participate, you do need to subscribe to the channel. So go ahead and subscribe so you can say hello in the chat or add some of your questions. All right. So Balwani's update. So today is Monday. Now, the trial schedule is usually Tuesday, Wednesday, and Friday. But this morning, there were a couple of hearings on the Sunny Balwani case. And as you recall, Sunny Balwani is the co-defendant of Elizabeth Holmes, the alleged co-conspirator. He's on trial for the same 12 counts of wire fraud that Elizabeth Holmes was. So what happened today is one of the jurors caught the virus, so the judge excused one of the jurors. So they're going to be replacing when they start tomorrow in the Balwani case, and that's going to be starting with the Balwani's defense. Okay, so his defense, he's going to be putting on whatever his defense is, whatever witnesses or evidence. So tomorrow, when the trial starts for Balwani, the judge will be replacing one of the alternates. Will go into the box of 12. Okay, so that leaves 2 alternates left. And they also indicated, the prosecution indicated they will not be calling Elizabeth Holmes. So Elizabeth Holmes will not be testifying in Sunny Balwani's case. She won't be testifying, but we don't know if she's been assisting the prosecution. And if you remember, if you've seen the video I did on calculating her sentence, I did several of them. One of the factors to reduce or to mitigate her sentence would be to assist the prosecution in the case against Sunny Balwani. But so she's not being called by the prosecution. That may mean they don't need her. That may mean that she's not participating or assisting the prosecution. I don't know. We'll get a better idea when we get the sentencing brief. She's going to be sentenced in September. So probably early August, we'll find out if the prosecution is going to be asking for any mitigation. And in other words, any reason to reduce her sentence. Okay, maybe she participated, assisted the prosecution, maybe not. But she's at this point not being called by the prosecution. All right, what else did we learn today? We learned that Sunny Balwani is only going to be calling 2 witnesses in his case, only 2. So technically, that means this case could be done this week. All right. So I don't know who those 2 witnesses are. Is he going to put somebody on to say that it's Elizabeth's company? Elizabeth makes the call. He wasn't making any of those decisions. In other words, he didn't agree to conspire with her. Or are they going to put maybe put a witness on? Maybe it's one of the former employees at Theranos who's going to say that, yes, Elizabeth was the one who made the calls and Sunny was just doing what he was told. I don't know. Is that what they're going to say? And again, this video is for information, educational purposes, only my opinion, and I want to know what your analysis is. So hi there, adorable girl. I see you there. Thank you for joining on the live stream. So Tony and an adorable girl, put a question. Ask me a question, or maybe haven't gotten there yet to ask. Okay, so Sunny's only calling 2 witnesses. So after Sunny, and by the way, Sunny Balwani at this point is not going to be taking the stand. Sunny Balwani at this point will not be taking the stand in his case. So that's kind of interesting. You know, it's a strategy call to make, whether or not you put your defendant on the stand, you know, and at this point, it sounds like Balwani's decided he's not going to be taking the stand. Maybe, you know, with all those texts that are out there between Sunny Balwani and Elizabeth Holmes, you know, where Sunny's making comments about Elizabeth's appearance on Kramer and maybe not wanting to make these kind of representations. You know, those kind of texts, that line of text that he made between with Elizabeth Holmes and the other text that he said with, you know, the lab was a mess. Maybe that's not a good idea to put him on the stand. I don't know, but you know, that's the defense's team. That's their call to make. In which way can she assist the prosecutors other than testifying? Oh, the good question, Arturo. She could be giving them information. She doesn't necessarily have to take the stand. You don't have to take the stand in order to qualify for assisting the prosecution and getting a reduction. Again, but that's a motion and a request that the prosecution has to make on her behalf. All right. I don't know. Maybe no one's helping anybody, you know? So, so we'll see. Is there a chance Elizabeth Holmes can be acquitted like the way? Well, I'm going to get to that. So let me finish with Balwani and then I'll get to the motion to acquit. Okay, so hold your question there. All right, so if he's only calling 2 witnesses, then the next thing that happens is the prosecution could put on a rebuttal case. So, but the rebuttal case is confined to only rebutting the evidence or testimony that Sunny Balwani's case puts on. So I don't even know if there's going to be a rebuttal case by the prosecution. It depends on what these 2 witnesses say. So in other words, this case could wrap up technically by the end of the week, and maybe do the jury instructions, advising the jury as to what the law is, blah, blah, blah. All of that before they get submitted to deliberations. That may not be till next week. We'll get a better idea probably tomorrow or Wednesday when this case is going to go to the jury for deliberations. All right, so let me go ahead. So welcome everybody to the live stream. Big shout out and thank you to all of you who have subscribed to my channel. Please do subscribe. Please support my work by subscribing. And so let me just give you a little background here. Elizabeth Holmes was convicted of 4 counts of wire fraud. Those 4 counts are the counts that she's asking the judge to throw out, to overturn. She's saying it's insufficient evidence that the government submitted, insufficient evidence of each one of those elements of wire fraud. All right. And a motion for judgment of acquittal is a very common motion that defendants make, and they want to test the evidence. They give the judge an opportunity to say, you know what, there wasn't enough evidence of knowledge. And that's exactly what Elizabeth Holmes is claiming here, that she knew that she agreed to conspiracy and she had knowledge of the wire fraud, right? Or some kind of fraud. So what's the likely outcome of her getting an acquittal? I'll talk to you about that in a second. But let me just get into the fact that she's going to be sentenced September 26th. But the judge has to make a decision on this motion for an acquittal. And there's a couple options. The judge can grant the acquittal. In other words, dismiss the counts, throw out her convictions, and she's free to go. The judge could deny, which I think is more likely, having listened to the evidence in the trial in the Elizabeth Holmes case. It's more likely, in my opinion, that this judge is probably going to deny this motion for an acquittal. So what's the next step? Elizabeth Holmes would file an appeal. She files an appeal with the Court of Appeals. Okay, so it's the trial court, the district court and federal court, trial court. Then it's the Court of Appeals. Then it's the U.S. Supreme Court. Unlikely to go to the U.S. Supreme Court because the U.S. Supreme Court only hears about 1% of the cases. So it might be the last word might be the Court of Appeals. So let's talk about an acquittal motion. So it's a very important motion that defense should make to test the evidence, to make sure there's sufficient evidence of each and every element of wire fraud. You know, did she agree to conspire with Balwani to defraud investors? Did she intentionally and knowingly commit fraud? And this is a request that the judge will rule on in probably next week or so, or a couple weeks. And the judge makes the determination based on the briefs that have been submitted. So the reply motion, which is what I went over with you in the prior video, and they're going to look at the government's opposition to Elizabeth Holmes' request for the motion for acquittal. Typically, the judge doesn't have a hearing on a motion for an acquittal, okay? So it'll be decided on what arguments they put in those briefs and what the law is. So I'm looking at my notes because it's Monday and I got to look at my notes. All right, I was a late bloomer. I'm learning while you're watching the video. Oh, good. I'm glad you're watching. All right, so so to sum up the motion, before I get into it, let me just give you some highlights. Basically, what she's saying is, I didn't fail. Right? My technology was successful. It was reported to me as being successful. She also is saying, basically, I didn't know. I didn't know that the conduct or that the technology wasn't working. Therefore, she didn't commit fraud based on those representations, statements she made to the investors. And I wasn't charged with that, is basically what she's saying, because she's saying in this motion, and I'll get to it, is that some of the arguments that the government is making and some of the evidence that the government has submitted doesn't support the allegations in the indictment. In other words, she's claiming, and this is true for every defendant, under the Fifth Amendment of the Constitution, you shall not be deprived of life, liberty, or property without due process of law. And what's due process? The indictment gives her notice of the charges she is being charged with, right? The wire fraud charges. And in that indictment, I think there are 7 or 8 allegations, making misrepresentations to the media, saying that Theranos was financially stable, etc. I'll get to that. What she is claiming, though, I wasn't charged with that, is that some of the evidence that she is claiming that the government submitted doesn't relate to these allegations. In fact, it's different than these allegations. And what it amounts to is what's called prejudicial variance. In other words, she's being prejudiced. She doesn't have an opportunity to defend herself because she wasn't put on notice of this particular evidence. And in particular, I'll give you one example. An example would be those logos. Remember where Elizabeth Holmes took the stand? She admitted that she had taken the Pfizer, the GSK and the shearing plow logo and put it on these validation reports that were put in the binder that was given to the investors. Okay, she admitted that she did that. She misappropriated. Well, that particular evidence and those facts are not in the indictment. Therefore, she wasn't put on notice. Therefore, she was denied due process. I think that's what they're alleging. Okay? So, and keep in mind, this motion for judgment of an acquittal gives us a clue. It gives us a clue of what her grounds are going to be for her appeal before the Court of Appeals. Okay, is everybody following me? Does this make sense? Let me know if this is making sense. Okay, so they have to prove, each one of these elements beyond reasonable doubt. And what they're claiming, what the defense, Elizabeth Holmes, is claiming is no rational juror would find that there's sufficient evidence for every element of wire fraud beyond a reasonable doubt. In other words, the prosecution didn't make their case. There wasn't enough evidence. And the review starts at the end of the government's case, before she put on any evidence, before she took the stand, because that's the first time the defense asked for this motion. So the judge looks at the record in the trial. He doesn't, when he's making this decision, he doesn't consider any other new evidence. He doesn't take any testimony from witnesses. He makes his decision based on the trial record and based on the arguments in the law that are in the motions filed by both the prosecution and the defense. Okay, so he looks at what did the witnesses say on the stand? What was the testimony? What was the evidence that was submitted? Does that show wire fraud? Does it meet the 4 elements of wire fraud? Okay, good. All right, good. It's making sense. All right. So the test is, Elizabeth Holmes is asking the judge, basically, judge, what do you think? You can think of the judge as the 13th juror here, right? Although the judge isn't involved in deliberations, he was there, he heard the testimony, and it's in his position to review all the evidence and make a determination. Did the government meet their burden of proof for each and every element, right? And basically, the standard is, if you're asking the jury to speculate about evidence, or if the government submitted scant evidence, then yeah, maybe they didn't meet their burden, right? But I think, in my opinion, there's plenty of evidence. But we'll see what the defense says in this motion, which I'll get to in a second. Okay, so the judge makes a determination. The judge looks at the trial record, looks at all the testimony of all the witnesses, all the exhibits, all the evidence, all the text between Elizabeth and Sunny Balwani, all of that, the logos, everything. And the judge's test is to look at the evidence in the light most favorable to the prosecution. So he weighs the evidence in the light most favorable to the prosecution, not to the defense, favorable to the prosecution. Okay? So that's why these are hard, difficult motions to win. Okay? But they have been granted. In fact, I have pages of federal courts, federal judges, district court judges, trial judges, who have granted acquittals, who have thrown out jury verdicts. Okay, I think I have over 7 pages here. All right, so, and I want to tell you about one particular case that took place in the Northern District of California, which is where Elizabeth Holmes' trial took place. And there was a judge who did throw out a fraud case. Okay, so let me get to that in a second. I got to go with my notes because it's Monday and I might lose track. All right, so typically the jury's verdict must be sustained if there's substantial evidence taking the view most favorable for the prosecution. Okay, they only set aside the verdict if the evidence gives equal or nearly equal support for guilt or innocence. In other words, if the judge looks at the evidence and decides that it's 50-50, then maybe the judge will lean towards an acquittal. But if the judge sees, no, this isn't 50-50, there's substantial evidence to show that there was an agreement with Balwani, okay, based on an inference of all the evidence. Okay, so you're not going to get in these kind of cases where, Sunny Balwani or Elizabeth Holmes are going to say, I agreed with Sunny to conspire to defraud investors. You're not going to get that. But what we do have in this case, in Elizabeth Holmes' case, all those text messages, those stockholder agreements, right, where the shareholders signed and bought, invested into Theranos. We have the validation reports. We have the testimony of Erica Chung, who talked about the reliability of the Edison, of the technology. Okay. We have the scatter plots from Tyler Schultz in the email that he sent to Elizabeth questioning the variance, the coefficient variance, the reliability of these tests. We have the testimony where they threw out some of the data points that were, when they were testing the blood. If they had data points that were outside, they would throw out the outliers. Okay. So, there's a lot of evidence that came in the Elizabeth Holmes case. All right. So let me get to the next point. Is it easy to win one of these motions to acquit? No, it's not. It's very difficult. Judges rarely want to interfere with a verdict of a jury. They're very reluctant to overturn a juror's verdict. Very reluctant. And to get a complete acquittal, in other words, for her to get acquitted on all 4 of these counts, is extremely rare. All right. And again, in my opinion, I think the judge is going to deny this motion. But we'll see. All right. So let me tell you about this 2019 case where a federal judge, a trial judge, threw out the prosecution's case. Okay. And in that case, it was, let me get my notes here. It was a 2019 case. It was the judge found that the government didn't prove one of the elements of fraud. And the element in particular was that the statements that the defendant had made or didn't make the judge determined was not material. In other words, this was a case involving a Barclays Bank for a foreign exchange option trader who was basically allegedly manipulating the price of the stock, and HP, who was also a client, was had some losses or had to buy the manipulated pricing. And so this stock trader, options trader, was charged by the government with 7 counts of fraud. 1 relating to conspiring, have we heard this before, to defraud an investor. In this case, it was the banking institution, because he was allegedly manipulating the price of the stock. And the judge found that the statements that this option trader made were not material, because one of the main witnesses, this is what's different from Holmes's case, one of the main witnesses in that case that the government called had said that they testified that they wouldn't rely on the statements. They would not rely on the statements made by this stock trader, by this option trader. Well, we didn't hear that testimony in Elizabeth Holmes' case. No one came in and said, well, I never believed Elizabeth. I never listened to anything she said. I never thought that anything she said was true. We don't have that testimony. But they do mention material in their motion, and I'll get to that in a second. So anyway, I just want to let you know that there has been a case where the Department of Justice had a case thrown out, a fraud case thrown out, because the judge stepped in and said, this is before it didn't go to verdict. This was after the government's case. So right after the government's case, this was during the trial, the judge stepped in and threw it out. Okay, because there wasn't enough evidence, because at that point, the defense had said the government had failed to meet their burden of showing every element of fraud. In other words, they didn't meet the material element of fraud. Okay? So I hope everyone's following me on that. All right, so let's get into if she loses, right? She can go to the Court of Appeals, and that's decided by 3 judges. It's a 3-judge panel, and it's based on the briefs. Basically, appellate judges, what they do is they do a lot of reading and a lot of writing. They don't listen to testimony. It's not a trial. They don't take new evidence, right? It's based on the briefs that are submitted, the arguments that are made by Elizabeth Holmes' attorneys. If they file this appeal, I'm sure they will, right? She wants to test this evidence. So they file a brief, they lay out what their arguments are, and we have a clue as to some of their arguments because we have that they made their motion to acquit. And the reason in the motion to acquit, they're basically laying the foundation. They're preserving issues for an appeal so they can raise it again. They can raise some of these issues again when they file their appeal with the Court of Appeals. Okay, so let's see what else. And the Court of Appeals, as I said, it's not a trial. It's basically they read briefs and they look at the law and they make a decision. They write an opinion. Okay. So their opinion will be to either, reverse what the lower court did, in this case, the trial court, throughout, reverse the convictions, or to uphold the convictions. Okay. So the Court of Appeals job is to make sure there weren't any errors at the trial court. So they're there to correct any errors, and those can be procedural errors. For instance, maybe the jury was instructed improperly, given a wrong definition of the law. Maybe a jury was selected improperly or dismissed improperly. Those are things that could overturn convictions, okay? They also look at whether the judge applied the law correctly or whether there was a mistake in the law. And they do in the motion bring up something about a jury instruction. So that to me indicates they're probably going to say this jury instruction was inappropriately given, which would be a ground to give her a right or to overturn her conviction, okay? So the grounds, now let's get into the grounds of her acquittal. She's one saying insufficient evidence. No rational juror, based on the evidence, could find that she was guilty beyond reasonable doubt. Number 2, the evidence that was presented by the government, as I mentioned earlier, was amended. It was different than what was said in the indictment. Therefore, she had no notice. Therefore, her due process rights were violated. And the court should throw out her convictions. Okay, so let me get into some of the motion here. All right, so if you look at the motion that the defense filed, I'll call it the acquittal motion. If you look at the facts in the very beginning, in my opinion, it's pretty interesting portrayal of Elizabeth Holmes, right? They set out the facts. They portray Elizabeth basically as someone with a noble intention, right? She was trying to change healthcare to improve access to healthcare and to lower costs. That's why she was doing it. And they're saying she basically worked hard. She developed this technology for years. She was surrounded by a lot of experts, right? And that she was told there were promising results based on her technology from employees at Theranos. She was told by the R&D people at Theranos that it demonstrated capabilities and it was, could match the best of the assays out there, basically. That's what they claim in their motion. And then she worked with the FDA, and the FDA did approve the technology for the blood test regarding HSV. I think it's it's slipping me here, but in the HSV test, she got positive feedback from Walgreens. She got positive feedback from the team at Theranos. And She did disclose the Venus draws. Remember in the trial, they brought up several investors said they didn't know that she was doing Venus draws. They thought it was only finger stick draws. Whether that was a misrepresentation of Elizabeth Holmes or not, whether it constituted fraud. And then she said that in this factual statement, or the statement of facts in this motion, basically what they said is Elizabeth Holmes learned that the results from the tests on the Edison were unreliable after the government audit, the CMS audit. So she learned later. She didn't know, I think is what they're trying to say. All right. But the jury convicted her of 4 counts, right? They didn't convict her on any of the patient counts. Those 4 counts, well, there were actually 3, came back not guilty. And then the 4th one, the government dismissed because they didn't have, they turned over the blood result late. So they didn't proceed on that one. But then we still have those 3 other investor counts, right? Counts 3, 4, and 5 relating to Alan Eisenman. I think it's Chris Lucas and Brian Tolbert, where the jury was hung on. Those counts have not been dismissed. They have not been dismissed. So technically, the government could try her on those counts, right? I don't know. Usually what happens in sentencing, depending on what the sentence is, that at that point, that's when the government would dismiss any of those, I'll call them undecided verdicts or hung decisions by the jury, those 3 investor counts. But we'll have to see if that happens, okay? So anyway, I thought the portrayal in the facts regarding portrayal of Elizabeth Holmes was, in my opinion, rather generous. But, that's what they think, and that's what she thinks, and they're entitled to say that, right? So let's get into the specific arguments and my take on those arguments. I got lots of notes here, so I got to get a little organized. Okay. Basically, what they're arguing is several arguments here. One, there was no evidence that Holmes and Balwani agreed to commit wire fraud. Number one, that's what they're saying. There's no evidence. And they're saying that the text between Elizabeth and Sunny, and if you look at the prior videos I did, they were constantly in contact. What was going on at the lab, whether or not they were getting, how much money they were getting for investors, the comments that she made on Kramer, what Balwani thought about that, trying to figure out who the whistleblowers are. All of those videos I did. The defense in this motion is saying that even though they frequently texted each other, kept in constant communication, that doesn't show an agreement. Even though they had joint discussions or they were joint decision makers, that doesn't mean they agreed to commit wire fraud. And even because they jointly participated in meetings, in the meeting that they had with the DeVos family, it was Sunny was there with Elizabeth. The defense is saying that doesn't mean that she agreed to commit wire fraud. And they're also saying that the emails that were sent to the investors, remember the emails that Sunny had sent regarding wiring instructions, the size of their investment, the defense is saying that still doesn't show that there was an agreement to commit wire fraud. Therefore, the government didn't meet that element. Insufficient evidence, the judge should throw it out. Then they said that there's no evidence that Holmes knew that her conduct was unlawful. There's no proof that she willfully joined any conspiracy or any agreement to defraud anybody. And what does that willfulness go to? If you look at the footnote in that motion, I think it's footnote 3 and 4, it goes to, they mention that Sunny Balwani was twice her age, and that if she didn't basically comply with what he said, she suffered abuse. That's how they're saying she didn't willfully participate. They're bringing up the abuse, right? Well, if I remember, they were together for 10 years, and Sunny served as the president of Theranos and the chair of the board. And I think, several people were investor. I mean, had abuse been I don't know. You can go look at my video that I did on the breakup text messages and revealing the text messages between Sunny Balwani and Elizabeth Holmes. I mean, granted, sometimes abuse happens. I was a former prosecutor of domestic violence. Sometimes, unfortunately, abuse does happen, and we don't know what goes on behind closed doors. But my take on those texts, it seems to be quite a loving relationship between Balwani and Holmes. And if you remember what Dan Edlin said, who worked at Theranos, who I think went to college with Elizabeth's brother, Christian, he said that it was Elizabeth who made the calls. He didn't recall a time ever when Sunny Balwani was able to overrule Elizabeth Holmes. So, what's your analysis of that? You let me know on that. So anyway, they don't think she willfully adjoined. That's what they're arguing. So my analysis is the big picture here is the jury can make inferences. They don't have to have, like I say, a direct statement from Elizabeth Holmes or Balwani saying, yeah, we agreed, and we agreed to defraud investors. They can infer from the evidence, from the circumstantial evidence, from the text messages, from them going to the meetings together, from, Sunny providing the financials, from them putting it in the binder, presenting it to the investors, for Elizabeth misappropriating logos, all of that, looking at the big picture of all the evidence, right? Would a rational juror conclude? I think they would. But again, this is the judge's call to make. Okay, so let's get into a more interesting argument here. This is the argument about whether or not they varied from what the allegations in the indictment were. There were 6 or 7 allegations, right? Financially stable. Did she make statements that it was accurate, reliable technology? Did they have a growing, expanding relationship with Walgreens, the partnership? Was the technology, I can't believe I remember all this, was the technology examined, used, and validated by research institutions and pharmaceutical companies? Did she make misstatements, misrepresentations to media to have those articles printed so then she could provide it to investors? Okay, so let's go through that. And keep in mind, all of this is setting up issues and preserving issues for her appeal to the Court of Appeal, to the next step up, okay? So they're claiming that the 5 allegations in the indictment, the ones I talked about, were not proved by the government. In fact, the government submitted different evidence. So again, she wasn't on notice. Therefore, they violated her due process rights. Okay? So, and if they did, then the judge could overturn the verdict, and so could the Court of Appeals. Okay? It's an interesting argument, whether or not they varied. So let me go through these allegations quickly with you. All right, so number 1, they argued that the evidence was insufficient regarding defrauding those 3 individual investors. And why that matters is because the amount of loss, just looking at the count 7, which relates to the DeVos family, the RDK RDV Corporation? Yeah, the RDV Corporation. They invested $99 million. And that takes her down. If you remember, if you looked at my calculating her sentence video, it takes her down the scale and increases her exposure to, just on that count alone, I think I'm right, I think it was over 4 years in prison, right? So if your defense, your strategy is you want to get rid of the amount of loss. You want to be able to kick out some of these counts. So then if she has to go to prison, right, if she's sentenced to prison, that she serves the least amount of time. All right, so they're saying that the evidence was insufficient not only to convict her on the conspiracy, basically she didn't know, right? She never agreed. I talked about that earlier. Now it's relating to those 3 wire fraud counts, and they're saying the evidence was insufficient. So let's go through those allegations, which they say the government didn't prove. Number 1, the proprietary analyzer. They claim in their motion, the defense says, that the testimony provided by Erica Chung related to the 3.0 series, the Edison. It didn't relate to the 4 series, which was the mini lab, which was the device that Elizabeth Holmes was talking to the investors about. In other words, all the testimony that Erica Chung gave saying that the technology, that Edison was unreliable, had no bearing on the statements that Elizabeth Holmes made to the investors, because she was talking about the next generation device, the 4 series. Okay, are you following me on this? All right. So they also said because the FDA approved the device for the HSV assay, that in other words, it was reliable. And they also said that the quality control tests, she never heard about that there were issues with quality control. That's what they're claiming. But, if you want to look at where that video I did where Tyler calls her out and shows her those scatter plots and sends her an email questioning the coefficient variance, right? He was saying it was more than the 10% that was represented by Theranos. It was anywhere from 18% to 63%, if I remember correctly. They didn't mention that in their motion, but I remember that from the trial. So they also said that Dr. Rosendorf also testified that he would never have released any results that were unreliable. Therefore, she never made any misstatements. She didn't know that any of this was unreliable. And she was, in fact, talking about the capability of a different machine. All right. That's what they're claiming. We'll have to see what the judge says. Hi, Catherine. All right. So put your questions. Do we have any other questions in there? All right. So the next thing that they said is that she didn't make any misstatements or misrepresentations when she talked to the investors, and hit that like button. When she talked to the investors about the financial stability of Theranos, she never made any misrepresentations. And this is why they say that. Number one, she was talking about the future projections. When they provided financials to the investors, they were talking about the future projections, right? So, in other words, it's not actionable misrepresentation. She was referring to future. And they also claim that the investors were aware of that because they said that Lisa Peterson, who was the representative for the DeVos family for the $99 million investment, they claim that she said that she was aware that they were projections were assumptions that they were making, and that Elizabeth had made representations saying that it was a major risk because it all depended on whether they could execute the growth of the company. All right. So they're claiming, again, this can be argued that this is, what their defense is, right? But the question is whether it was sufficient evidence to support this financial stability. And they also claim that the investors knew that it was speculative. It was speculative risk. In the shareholder agreement, they were told that it was speculative, highly speculative, right? And they're saying this, so there was no evidence that she defrauded. She didn't make any misrepresentations. They were, it was future projections. And they also said that she didn't know that they had modest revenues, which is what the prosecution alleged. She didn't know. Again, she didn't know. All right. So just because the evidence contradicts, that's why you have a jury. The jury weighs it and says, do I believe this? Who do I believe? Who's more credible? What's the evidence say? Where does it point? Does it point to guilt? Does it point to misrepresentations made or not? All right. So the next thing they said was the Walgreens partnership. There wasn't sufficient evidence of that. The government alleged that the Walgreens partnership stalled, and Elizabeth Holmes didn't tell the investors that. All right. They're claiming, Elizabeth Holmes is claiming, there wasn't any stall out in the Walgreens because they were able to roll out more stores. In other words, they went from 40 stores to 200. So that shows that it was a growing business relationship with Walgreens. So she didn't lie about that, is what they're claiming. They said that that Walgreens was the one that modified their goal to drop it from 500 stores wellness centers that they would open to 400, and they didn't tell Elizabeth, so she didn't know. But then there's that text where Balwani texted Elizabeth and said, can't scale with Walgreens. In other words, the government was arguing, there's Balwani admitting to Elizabeth that they were stalling out. They couldn't scale with Walgreens. Well, the defense argues in this motion, no, that's not what that text means. That text means that they were thinking about focusing their efforts on Safeway and CVS. Had nothing to do with any stall out with Walgreens. All right, then another allegation. What did Catherine say? Unbelievable, astonishing, not buying one tiny bit of this reframing. I thought she knew every job. Yeah, okay, can I just say this? I'm going to say this. I haven't said it before, but I'm going to say it. Here's a woman. Okay, this is just my opinion. I could be wrong. Here's a woman at age 19 drops out of Stanford because she has a dream. She believes in this company that can change healthcare. You know, one tiny drop changes everything. She stays up for nights putting together this patent application. She spends 10 years, approximately 10 years in stealth mode, having the technology, reworking it, trying to get it to work, doing all these different tests, doing clinical studies, being involved in all of that. Are we to believe that she's hands off? That this technology that she created, that she has a patent on, she never checked in with? She didn't keep an eye on this technology? She basically handed it over to the people in the lab? Are we to believe that? That she would be hands off her own technology, her dream? Okay, moving on. So, Department of Defense, that was another one of the allegations. So, the prosecution alleged that Elizabeth Holmes claimed that she deployed the Theranos technology in the battlefield. Remember, I think it was General Mattis. I think he testified to that. I'm not sure. I know Edlin testified to that. That basically they had issues with the temperature, the extreme temperature, that they weren't able to roll it out, to use it, to deploy it in the battlefield, is what the prosecution argued, right? Here's what the defense says. They say that it was deployed in 3 countries. They did deploy it in 3 countries. And that they also, one of the allegations the prosecution made is that Elizabeth Holmes led the investors to believe that it was a revenue generating operation. They were getting revenues from the Department of Defense. Well, the defense in a footnote in this motion indicates that Theranos did receive payments from the American Burn Association. So I guess, is that a payment? I don't know. And they also said that regarding Edlin's testimony, that they were using it clinically to clinically treat patients, which wasn't what was alleged in the indictment. So therefore, that testimony doesn't support what was alleged in the indictment. It's something different. It's a variance. It's amending the indictment, therefore violating her due process rights. Okay? Then they get into that investor call. Remember the call that Elizabeth Holmes had with several of the investors? I did a video on that. I let you listen to those 7 little clips of the statements that she made. How does the defense portray that investor call in this motion? They say that Elizabeth Holmes was talking about the potential application, not that it was actually being used and deployed currently, but it was potential application. Therefore, the government didn't meet their burden. And then the next allegation is the use of the modified and the unmodified devices. Remember, Theranos would buy third-party machines, Siemens machines. They would modify them. And they wouldn't disclose the modification because Theranos, Elizabeth Holmes, claimed that that was intellectual property, trade secrets, so they didn't have to discuss that with investors. But did she tell investors that they were using third-party devices? Or did she tell them that they were only using Theranos devices? Okay, so the defense said that Elizabeth made no secret that they were using third-party devices. It was on the test menu. It was on the Theranos website. It was in the press releases, and that some of the witnesses testified that they had read the website. They had read the press releases. Therefore, she didn't make any misrepresentations. But what did she tell the investors? You know, or does it matter that it was on the website or on the test menu? I recall several investors saying they weren't aware. I don't even think General Mattis was aware that they were using third party or they were doing Venus draws. They're claiming she made no secret of it. And that they also say that the investors were aware there were Venus draws. In other words, not finger stick, but from Venus draws. And they point to the fact that Brian Grossman, which is count 6, is that right? Yeah, count 6, which is the $38 million that she was convicted of defrauding. They're claiming that because Brian Grossman got a Venus draw that he knew that they did Venus draws. They also say that because of the trade secret, because they modified, why were they modifying these devices? But they modified these devices. That was intellectual property, as trade secrets. They didn't have to disclose. Like every company has trade secrets, all right? So those are several of the arguments they made. And I'm looking at my other notes here. You know, what do you think? What do you think is the big picture? You know, the jury convicted her. Is any of that compelling to you? Do you think a judge is going to be persuaded to overturn a jury's verdict based on that? Do you think that was insufficient evidence, or do you think there was sufficient evidence shown at trial? Okay, so, you know, they have to prove, even if the government presented evidence that's different than what's in, you know, specifically written in the allegation, in the indictment, they have to show that it's substantially prejudiced Elizabeth Holmes. And what's substantial prejudice? That's something, you know, the judge is going to have to consider, and the Court of Appeal if she files an appeal. All right, let's see. And in his ban, in the text, she proposed to Balwani that they lie about the third-party machines to Walgreens. Yeah, well, you know, the defense is testing the evidence. And, you know, it's, as I said, it's very common that the defense brings a motion for judgment of acquittal. They want to test the evidence. Okay? That's their job. All right. So the prejudicial variance argument, I think, is pretty interesting. And whether or not it was, you know, the evidence at trial amended the indictment at all. Whether or not, you know, this judge is going to be persuaded by that, whether or not it's going to be a legitimate or a successful argument to be made with the Court of Appeal. You know, constitutional rights are very important. And, you know, when you're deprived of life, liberty meaning your freedom, meaning you're going to go to prison, right? Without due process of law, you know, there's a reason that indictments list out what you're being charged with. They indicate the facts to support it, right? Which is what is in this indictment. And in this indictment, they also indicated, you know, those specific allegations. They indicated her specific misrepresentations that she made that the government argued constituted fraud and supported a conviction and several convictions. All right. But the thing is, you know, you can't sandbag a defendant. You can't, like, so for instance, in a lot of these cases that I looked at, in these many, many pages where they did overturn based on prejudicial variance or amending the indictment because the evidence that came into trial was different what the indictment said, It related to incorrect dates in the indictment. It related to not identifying the right parties in the indictment. There was, let me look, it related to charging a defendant with, let me give you an example. So when I was a baby prosecutor years ago, when I was a DA, one of my colleagues in a DUI case, driving under the influence, in those cases, defendants are usually charged with 2 counts. Okay, 1, driving under the influence of alcohol, and 2, driving with a blood alcohol level greater than 0.08. So in the trial that my colleague put on, I wasn't a part of this trial. I just heard about it. I'm just using this as an example. Not saying anything bad about my colleague, but in that DUI trial, she never put on any evidence to support the charge of being under the influence. She brought in the blood alcohol test, right? She brought that in to support the driving with an alcohol of 0.08, but she didn't bring in any evidence, no expert to say how alcohol impairs your driving. So guess what? The judge threw out that count. Okay? Because it was insufficient evidence. There wasn't any evidence. I don't think that's the case in the Elizabeth Holmes case. All right, so here's a case in particular. It was a 1990 case in the 11th Circuit. Different circuit than California. We're in the 9th Circuit. She appeals. It'll go to the Court of Appeals for the 9th Circuit. This is an 11th Circuit case. It's something a judge in the 9th Circuit can look at, but it's not controlling. Okay? In that case, the indictment only named one individual. It didn't name anybody else in a conspiracy case. It turned out in the government's case that they were referring to someone else not mentioned in the indictment. The 11th Circuit concluded that it constituted an amendment to the indictment, and they created a distinction between an amendment and variance. And I hope this isn't going into the weeds, but anyway, listen to this. The proper distinction between amendment, not a mere variance or a difference from the indictment, the proper distinction between an amendment and a variance is that an amendment occurs when the essential elements of the offense contained in the indictment, those 4 elements for conspiring to defraud and wire fraud, the essential elements of the offense contained in the indictment are altered to broaden the possible basis for conviction beyond what is contained in the indictment. So that's what the defense is arguing, that the prosecution in their case, they're broadening the scope of the indictment. They're altering it. Therefore, they should overrule the jury's decision. They say a variance occurs when the facts proven at trial deviate from the facts contained in the indictment. A variance occurs when the facts proved at trial deviate from the facts contained in the indictment, but the essential elements of the offense are the same. So is Elizabeth Holmes going to be able to convince this judge or any, the judges on that Court of Appeals, those 3 judges, that the evidence that the government presented varied, was something different than what was alleged in these allegations? Even though there might have been additional evidence, but did it alter the essential elements of the crime of wire fraud? That's going to be a tough one. And it really is going to come down to how well they write their brief, their arguments that they make, and the case law that supports their arguments, how well they write their brief for the Court of Appeals, because you don't always get oral argument. And if they're given oral argument in the 9th Circuit, they only get 10 to 15 minutes to make their case. So you got to write a really good motion. Speaking of which, did you notice in that motion that was filed, this motion that I'm talking about, the acquittal motion, did you notice that there's a new kid on the block? Did you notice that there's a new attorney named? Who was the first attorney named on the motion. Go ahead and take a look at that. That attorney, I think, was pulled in, is hired to handle this appeal. All of this is laying the foundation, the groundwork, preserving the appeals that they're going to argue potentially at the Court of Appeals, right? So, and then they say it's a fundamental right in our system of criminal justice that a defendant has a substantial right to be tried solely on the charges presented in an indictment returned by a grand jury. So was she tried solely on the charges of wire fraud? Those 12 charges, or 11, right? 11 charges. 2 conspiracy, the 6 relating to investors, and the 3, because they didn't proceed on one of the patient counts. Was she tried on those charges or something else? And that was an indictment handed down by the grand jury. This indictment was the recommendations of the charges made by the grand jury based on the evidence that they heard that the prosecution presented. And based on that indictment, Elizabeth Holmes and Sunny Balwani were charged with those 12 counts of wire fraud. So, what do you think? All right, so I'm ready. Questions. In the text, she proposed to delight about, third-party machines to Walgreens. Yeah, that's a good point, Anne, is banned. Catherine says, it appears Ms. Holmes filled the sandbags. Oh, that's clever. With the Ninth Circuit, see the twisting of the evidence, the alteration, the variance, and find it worthy of dumping the jury's verdict. Gruesome. As I said earlier, judges are very reluctant. These are 12 jurors. I was there for over 4 months, right, of this trial. 8 men, 4 women sat. It's part of their civic duty. Sat as jurors. They listened to the evidence. I saw them taking notes. I found them to be attentive, right? They were admonished every day by the judge and asked every day, every morning, did you look at any news? Did you do any research? In other words, did they make the decision based on only the evidence and the testimony in the courtroom? Nothing to do with reading any book or watching any series. No, based on what they heard from the witness stand, And this jury, they were out deliberating for several days, and they came back, and I said this on the eve of the verdict, I found it to be a very fair verdict based on the evidence and the testimony that I heard. Okay? So they came back and convicted her on 4 counts. Problem is, those 4 counts, because of the amount of loss, right, exposes her to significant prison time. But it's not final. It's not final. This verdict is not final until the appeal is final. And how long is that going to take? If she goes to the Court of Appeal, usually it's about a 6-month briefing schedule. Briefing, prosecution, the defense submits their brief, prosecution responds, takes 6 months, and it's another 6 months to probably process this. They have a backlog of cases in the Ninth Circuit. It could be a couple years before we get a decision on whether the Court of Appeal says yay or nay to her request, assuming she submits an appeal. And it looks like they're going for an appeal here, okay, to overturn and to convince the Court of Appeals that the trial court made a mistake, an error. The appellate court is there to correct any errors and to make sure that, defendants got a fair outcome, right? So, based on the procedures and the law, that the judge gave the jury, instructed the jury, based on the rulings that they were made, whether evidence comes in or out. Okay, so the fat lady may not be singing, but she is in the green room gargling. Yeah, I got a joke for you. Here it is. So do you know Groucho Marx? So he said he was married by a judge. he wished he had been married by a jury. So, Elizabeth Holmes, she was heard by a jury, okay? She has every right, like every defendant, to appeal these convictions, okay? And, to let this judge decide on this motion whether or not he's going to find that there was insufficient evidence of these elements of wire fraud, that the government didn't put on enough evidence. It's up for this trial judge, for the judge to decide whether or not he's going to grant this motion for an acquittal. And if he doesn't, then it's more than likely going to be appealed. She'll appeal it to the Court of Appeals. Okay? So, any questions, you guys? Questions? Let me see if I have anything else. I have some subscriber questions. How are we doing on time? We're a little bit over. Are you guys okay if I go 5 more minutes? Yes? Okay, so shout out to Hope SF, one of my subscribers. She said it's crazy, this motion for an acquittal. It seems Elizabeth Holmes will never admit she's wrong from the start. Well, Hope, she does have a right to test the verdict and to test the evidence. She and Hope said, how offensive to the jury who carefully listened to all the testimony and made their decision. She said she's read Bad Blood twice. She needs to be held accountable. That's according to Hope. And I said, good point, Hope. Judges are very reluctant to overturn a jury's verdict, but they have done so, as I indicated to you. All right, then another shout out to Punji Fungi, one of my subscribers. He or she said, this thing insults the jury, implying that they are not rational. Yeah, I know. It says no rational juror, no rational trier of fact would find there's sufficient evidence. That's just the legal term, right? It does sound like, rational versus irrational jury. Again, they have to pretty much show that the jury speculated, that there were scant evidence of each one of these elements. How ironic when the defense used emotional tactics employs to get her off, is what he said, or he or she said. She is desperate as September is looming, the sentencing in September. Then one of my other subscribers, Internet Polification, shout out, said, I simply cannot see the point in a jury if you can do a motion to acquit. All that fuss, picking jurors, trial, jury verdict, and then a judge can overturn it all. Well, the judge is there as a safeguard, to make sure that there is sufficient evidence. And he was there all along making rulings. He was asked at the end of the government's case to make a ruling whether there was sufficient evidence. He reserved his ruling. He was asked again, was there sufficient evidence at the end of the defense's case, at the end of the case? He also reserved his ruling, and now he's asked for the third time. What's your ruling, Judge? Are you going to give Elizabeth Holmes her acquittal? Okay, and I said this is just, think of this motion, and again, they're commonly filed by a defense attorney, by defendants. Think of it as a check on the system. You want to make sure there's sufficient evidence. We have a constitution that requires people to be proven guilty beyond a reasonable doubt. There has to be evidence to support each one of these elements. That's what our American justice system is based on. Okay? Another shout out to Anton, one of my subscribers, said this is a motion for judgment of acquittal, notwithstanding the evidence. I thought that was pretty hilarious. Very clever. Then shout out to Andrew Bush, who said Michael Avenatti was just sentenced to 4 years for defrauding a client. Stormy Daniels, $400,000. That was her, I think that was her retainer for her book deal. Can one gather from that sentencing that Holmes will receive a much longer sentence for defrauding? Well, Michael Avenatti's case was also in federal court. He wasn't charged with these particular offenses. And yes, it can show as a guide, Avenatti got 4 years. Remember, if you go through the sentencing guidelines based on the amount of loss, which what is it? 100 and it's at 199, 38 and 6. What is that? 138. So 141. What did I say? 141, 144 million. That takes her way down, exposes her to years because of the amount of loss. Over $140 million, not 400,000 that Michael Avenatti, right? But it's there to show, these judges take these cases seriously. Okay. So another comment was, and all the jurors were therefore irrational. Their verdict was irrational. Well, appeals are hard to win. Motions for judgment of acquittal are hard to win. I don't know if this is sufficient enough to convince a judge in this motion. I will say that their argument regarding a variance from the indictment is an interesting one. Whether the evidence at trial amended the indictment, that's interesting. The other arguments, whether or not she knew or agreed, I don't know about that. I think the evidence is pretty compelling there. But again, just my opinion. Okay, so I don't have anything else. Do you guys have any questions? Or should we call it a wrap? How are we doing? Any other questions? So again, Balwani's got 2 witnesses for his case. So that 5 weeks of trial that's scheduled out doesn't look like that's going to happen, although we never know day to day. He's only calling 2 witnesses, and it looks like at this point he's not taking the stand, and he's not calling, and the prosecution is not calling Elizabeth Holmes. So it might be a quick wrap up on Balwani's case. But then the judge needs to instruct the jury, right? Then they need to go into deliberation, figure out what their verdict's going to be. If they have any questions, all of that. Remember what we went through back in the Elizabeth Holmes case. So it could get wrapped up. The jury could get instructed. It could go into deliberations. Could be handed to the jury next week. We'll see. You never know. These cases are always changing, though. Okay, so any other questions before I sign off? Hit that like button. Do subscribe. Oh, here we go. Thank you. Thank you, Catherine. I appreciate it. Again, if you want to support, donate, super chat, as they call it, I put a link to PayPal in the chat box. And it's also in the description box below the video. So I just want to shout out to all of you and say thank you so much for supporting my channel, helping it grow. I really enjoy reading all of your analysis. I mean, that's why I created this channel, to get your analysis. I could just be talking to myself. So, I want to know what your take is. And it also gives me an opportunity to share my knowledge, the years and years of trying cases and training lawyers how to try cases and providing legal analysis on cases. And also, talking about the Constitution, talking about the American justice system, and that we have these checks and balances, right? We have the Court of Appeal to review what happened at the trial court, to make sure that defendants aren't wrongfully convicted. Okay, and they have every right to appeal these verdicts. Okay, so thank you very much, everyone. Thank you for watching. Keep supporting my channel. Keep sharing these videos. Hit the bell notification so you get the next video when I have something interesting to say. And I'll keep you posted on Balwani. We'll see what happens. How the judge decides on this motion. Again, I don't think it's going to be granted. But it does give us a clue on what her grounds for an appeal might be. We'll see. So thank you very much, everyone. Thanks for watching.